Hello, this is IP Stories by 4IP Council, a podcast about innovation and intellectual property. Join us and you'll hear about the journeys through invention, creation, and IP understanding of our guests.
I'm Axel.
And I'm Marta, and we have with us today Tamany Vinson Bentz, founder of California IP Law and an IP attorney specialized in technology and media. Hello, Tamany, and thanks so much for joining us today in IP Stories.
Hi, Marta. Hi, Axel. Thanks so much for having me.
So I think our listeners would like to know more about you. So I would like to start with your personal story. What sparked your interest in intellectual property, and how did you end up focusing on digital businesses, media, and technology?
So I came at IP law and digital media from a completely different direction. I didn't go to law school to work in digital media. I didn't even go to law school to be an IP lawyer. I went to law school because I had a science background and I wanted to work in science policy. I had an externship in college with the American Association for the Advancement of Science. And while I was there, I wrote a pamphlet on stem cells. So for anybody who doesn't remember the 90s, stem cells were very controversial. They come from human embryos, and you have to make a human embryo to get the stem cells, and the human embryo does not survive the collection of stem cells. So in the United States, it was very triggering politically that we would be funding stem cell research. My job was to write the documents that would educate Capitol Hill and the people working there on what's the science of stem cells, not the political issues, but the facts of stem cells. And I loved that job. And I wanted to be the person who would teach people who made policy about science. That's why I went to law school. When I was there, though, two things happened that completely changed my mind. One, I really loved a class called Civil Procedure, which for anybody who doesn't practice law in the United States is the rules of court that we abide by. And I loved that class, and everybody hates that class. And I also had a patent teacher who pulled me aside and said, "You have a real aptitude for patent law." And that was probably the only time in law school somebody told me I had an aptitude for it. So I decided I should leverage what I was good at and what I loved, and completely changed my mind and decided to be an IP lawyer. So when I graduated law school, I was doing pharmaceutical patent litigation, as you can imagine, with a background in biology. And eventually, though, I moved to Los Angeles. And when I did that, there wasn't a lot of pharmaceutical patent litigation in Los Angeles, as you can imagine. There was a lot more copyright and trademark work in Los Angeles. So my practice became focused on how my technology and background and science background really overlaid with entertainment. And luckily for me, I landed in LA right when digital media was taking off. So it gave me a great opportunity to be the person who understood the technology, but also could understand the legal entertainment issues that were going along with digital media.
No, I like the way that you changed gear at one point, and you decided to totally switch or change your, the sector you were working with. And to be honest, I was more expecting you to become a lawyer, to do IP in the sector you were already working with. Like that would have been quite normal. But in your specific case, that's surprising. You change location, you change topic, you change everything. But if I look at what you have done, and do you have one favorite case or experience that really shape your view on IP in digital after already starting your new career?
Yeah, I do. I was lucky enough to work with a client very early on in digital media. They were a client who was acquiring viral videos and licensing them out to mainstream media. So they had a library of viral videos. They got embroiled in a fight over whether other people on social media could use their viral videos without a license. So it was the first case that I am aware of in the United States that considered copyright protection for viral videos and how far fair use was going to go in allowing people to use those viral videos on social media without a license. What was so fascinating for me about that case is that it was so early on in social media that it was really just YouTube. When you talked about social media, you were really talking about YouTube. The idea that YouTube could make money was new to everybody. I remember in that case, having to explain to the judge what YouTube even was. And I realized that digital media and technology was outpacing the law. And we were going to have to do a very good job at educating them on what we were talking about and why it was so valuable before we could even get to the questions of copyright protection and fair use. And that case made me realize that we were looking at very old cases that had nothing to do with video. They had nothing to do with digital media. They had to do with art and music. And it was up to us to take those old precedents and apply them to the new technology.
I have done a bit of research, and I know that you have advised a wide range of clients in tech and media space, as you were mentioning. So what's the most common mistake you see companies making when it comes to IP?
So this is a mistake I see companies make, not just in digital media, but I think in every industry. And that is that they rely on one type of IP. Good IP protection is kind of like an onion. It has lots of layers. It has lots of different things built into it. And the reason that's so important for companies is because you don't really know if somebody tries to enter your market, how they might try to use your ideas or your technology. So layering in different types of IP protection gives you more leverage down the road to protect your space in the market and protect what belongs to you. But all too often I see a company go, okay, well, I have a patent, so nobody else can do this. And they don't realize that you can design around a patent, right? Or they have a patent, but it's not really that broad at the end of the day. So they might have been better off to get some other types of protection around their patent so they could try to defend their space in the market. I see that a lot in digital media, but I see it even in every industry.
That's very interesting, because now we hardly believe when we see a company that is not digital, but there are still a few, I think. Yeah. But IP and digital, clearly we can imagine that companies are facing lots of challenges. But what are the biggest IP challenges that companies face, in your opinion, or maybe that what you have seen in the past?
So I think for any company dealing with digital assets, one of the challenges can be finding the source of the infringement. It's very easy for it to turn into a game of whack-a-mole on a digital platform when you try to enforce your rights. So finding the original source can be difficult. We can talk about the social media platforms and how some of these companies can best deal with some of those platforms that they monetize on. But I do think avoiding the game of whack-a-mole is one of the biggest challenges. This isn't necessarily an IP issue, but I think another very large challenge in the digital space is going to be data. And it will always be data. Companies dealing in the digital space will always be collecting data and using data. And right now, the landscape on the laws around data vary greatly. So sometimes those can get embroiled in IP issues too, but I see that as a very big pain point in digital media.
Yeah, of course. And now that we see, more and more legal battles around social media content, from influencer disputes to AI-generated music takedowns, what should businesses and especially content creators keep in mind to avoid IP trouble in this space?
So I think what they should focus on is a strategy for what they're doing at the very beginning. Often you see companies who are creating content not focus on IP protection for their content. They invest a lot in creating content, and then what they want is that viral moment, that moment when they create a movement in their community or their country or their industry, but they don't protect it before they do that. So then a lot of times what you see is other people take that. They take that idea, they take that name, they take that strategy, and they implement that themselves, because that's very much how the digital media ecosystem is set up, right? We all watch it. And when you see something that you think is a good idea that you might be able to use for your business, you start to work on how you would implement that. So the thing that these companies could do the best is to start with the IP protection when they start launching the content and the strategy for what they're going to do and how they're going to protect it so that they're able to monetize it down the road.
It was already complex for companies to become digital. But now, if we take into account AI, I suppose that AI is changing how we create, distribute, and protect content. What's your take on the current debate around AI-generated works and IP ownership?
So I'll start with the question of IP protection for things created with AI. Right now in the United States, you cannot get copyright protection for things that are created by AI. It's a little bit different in China, but in the United States, it's very clear the Copyright Office is not going to give protection to things that are created with AI. I may be in the minority of practitioners in the United States, but I think that that's actually wrong. It would not surprise me if in the United States the pendulum did not swing in the other direction, and in the next 5 to 10 years, you see them extend some protection for works created by AI. But there's a pretty specific reason for why I think that. We talked about how I have a lot of experience taking old laws and applying them to new technology. And in this case, I think AI is very analogous to a camera. So in the olden days in the United States, there was a discussion about whether you could get copyright protection for photographs, because at the end of the day, the photograph is created by a machine, the camera. The reason we settled on giving copyright protection to photographs was because the people pushing the button on the machine were choosing the angle, they were setting up the lighting, they were staging the photograph. All of those things are very similar to what a person would put into a large language model, an AI system, in order to create something. So because of the analogy between a camera and an AI system, I think eventually we may see some protection for works created by AI in the United States, but I see that being 5-10 years down the road. There is no doubt, though, that AI is going to revolutionize every industry and how they work. And certainly I've talked to many companies that are changing the way they create content and relying more heavily on AI. And I think that's true across every industry. They are doing it even knowing that they may not get copyright protection for what they're doing at the end of the day, and knowing that it may make their IP protection more complicated in the United States at the end of the day.
Mm-hmm. I really like the fact that you have that not very popular opinion, because it's always good to have guests with different opinions. And actually, the comparison that you did with the camera, I think it's very clear. Now, I would like to focus the attention on the streaming services. So, e commerce platforms and social networks, because they have become major battlegrounds for IP rights. Do you think these tech platforms are doing enough to protect IP, or do you see gaps that still need to be addressed?
I actually think that the platforms do an okay job with IP. I think there's a lot of automation now in what they do with IP and the notice and takedown procedures related to IP, and that automation causes problems. So, for instance, I'm working right now for a client who is in a system on a streaming platform where they have to share revenue with certain music publishers. The problem is there's no music in their content. So they've gotten snagged in an automated claim process that's claiming their content for some reason we can't figure out because it has no music in it. And they can't get out of it because the process is so automated that they had to hire somebody like me to go get a human being at one of the streaming platforms to look at this and understand why it was such a problem. So I think they do a good job, and there's a lot of functionality there for people who own IP to protect it. But I think it's so automated that when the system makes a mistake, it's virtually impossible to get out of the mistake, and that's a problem. They're very incentivized to do that, though, in the United States, because we've kind of taken the position that if they have a system by which they will protect IP or take down infringing IP, then we will give them safe harbor. So for that reason, I think they do a reasonably good job given the amount of content on some of these platforms. But, they obviously fail in a lot of other areas not related to IP.
That reminded me how we have all been locked out of Meta at some point in our lives, because the whole thing is so automated that desperation of trying to get hold of a human being and be like, hey, really, this is me, Marta, this is my account.
Yes.
It can be so tiring. I guess they have to have it automated because it's a lot of people. But yeah, sometimes you do need to have people behind as well.
No, definitely. One of the issues today is everything is global. So that would be so difficult to have a service that will cover all the languages, potentially also some cultural differences. The fact that everything is global is also a good thing because it makes life easier to deploy services and solutions. However, in IP laws, that's not really global. IP laws vary from country to country. So I would like to know, Tamany, what are some of the biggest headaches when dealing with IP on an international scale, in your opinion, or maybe that you have faced lately?
So the biggest headache is finding people internationally. And then when you find them, figuring out, how to deal with the issue. So I tell this story to my clients to kind of articulate this for them. I had an issue for a client, and they had gotten into an IP dispute on a social media platform with a very lucrative YouTube channel. And because of that dispute, the owner of the YouTube channel had started to reach out to the employees of my client on WhatsApp in a harassing and threatening way. So for the client, even though the IP issue was being taken care of on the social media platform, they were concerned for their employees. They wanted to take some action to protect their employees. So we had to track down who owned this very lucrative YouTube channel. And initially, we were able to confirm it was not somebody in the United States. And then we figured out it was somebody in Germany. And we worked with German authorities and with lawyers in Germany to try to figure out who this person was, just so we could get them to stop harassing employees. And it turned out that it was a minor in Germany who was running this YouTube channel. I don't even know how he was explaining to his parents how he was making so much money off of YouTube.
Yeah, that's crazy.
But that was one of the cases where it just highlighted was not expecting it to be a minor in Germany. And that, of course, raised a lot of other issues under German law that we needed to address before we could even approach this individual.
Yes, because I guess a minor is not allowed to have a YouTube channel, right?
I think in the United States, I don't know what the law is in Germany. That's a good question. But in the United States, you have to be 13. He was over 13.
Oh, okay.
But he was not of legal age in the United States. I assume he wasn't in Germany either.
Mm-hmm. Wow, that's crazy. I would like to because we only have a few more minutes. So before we go, I would like to ask you about startups because they are like my soft spot. And I know that a lot of them don't always prioritize IP in a very early stage. You cannot really blame them though, because they do have a lot of things to juggle. But I would like to ask you, what advice, sort of like top advice, would you give to entrepreneurs, and especially to those looking to build a strong IP foundation in digital and tech businesses?
So what I tell all entrepreneurs and startups that I work with is the first thing that you should think about when you think about IP protection is what of what you are doing, what is valuable to the company? What is it that makes you, if you're selling a consumer product or a service or a software, what is it that makes it better than what's already out there? What is it that you would call your secret sauce? What is your innovation? And then focus on that. Focus on IP protection for that, because when you focus it around that, number one, you're investing in IP that's actually going to return on your investment because you're investing in what you're monetizing. And number two, IP protection becomes much more focused and much clearer. And it enables you to do what I spoke about earlier, which is like this onion approach of layering in IP to make sure that you're fully protected. But what I often find with entrepreneurs is that they don't really take the focused approach. They either have somebody tell them like, oh, go get a patent and you'll be fine, or don't go get a patent and rely on trade secrets and you'll be fine, or get a trademark and you'll be fine. But they don't necessarily make sure that what they're getting relates to what they're making money off of at the end of the day.
Yeah, I think that's a great advice, because every single business is different and they should focus on what they are doing.
But one of the great things is that technology is always evolving. And we have seen new emerging technologies coming every 2 years. And you don't have the time to adapt that a new one is coming up. So with all those emerging technologies, metaverse, blockchain, AI, quantum computing, how do you see IP evolving in the next 5 to 10 years? Are there particular trends we should be watching?
So I think blockchain still has a major role to play in IP on two fronts. I continue to think that blockchain technology can revolutionize how people enforce their IPs and how they avoid that whack-a-mole problem that I was talking about earlier. I haven't seen it implemented yet, but I still think the technology will get us there in the next 5 to 10 years. Obviously, blockchain will create an entirely new type of content that people can monetize. You've seen NFTs be monetized. I think you will continue to see an expansion of that in the next 5 to 10 years. I think obviously AI is going to revolutionize digital media. It's going to level the playing field on content creation quite a bit. So, because it's much easier now for people to create content with AI, but I also think it's going to drive content to be more similar, right? If everybody is using the same AI platform with similar prompts to create their content, I think in the next 5 years or so, you will see a convergence of similarity in content, which is going to lead to some very interesting IP fights involving AI. Obviously, the fight over whether large language models can use other people's content to educate the model will be decided in the next 5 years. And I think that that will very much change how AI is implemented for technology.
I think we will be amazed by what we will see in the next 5 to 10 years. So I'm pretty sure that your job will be more and more important.
This is all very exciting. I'm also looking forward to see how things develop in the next few years. Tamany, thank you so much for coming to our IP Stories podcast and share your knowledge and experience with us today.
Thank you, Axel. Thank you, Marta. It was a lot of fun.
Thank you, Tamany.
Thank you for listening to IP Stories by 4IP Council. Visit our website on 4ipcouncil.eu to find out more and check out the links mentioned during this episode. If you liked it, remember to share and subscribe.